My name is Nathan Kumpashaya, and I will be talking about chemical regulations and management in Thailand today. These are the topics I will talk about today. Start with a very brief introduction of the country, the principal chemical management legislation in Thailand called Hazardous Substance Act, the inventories and chemicals nomination, and how ChemADVISOR can provide assistance in terms of regulatory compliance or adding your chemicals to the inventory. Thailand is located in Southeast Asia. It is contiguous with Cambodia in the east, Malaysia in the south, Myanmar or Burma in northeast, and Laos in northwest. The total area is approximately 520,000 square kilometers, or about 198,000 square miles. It is a tiny bit smaller than Texas, which is almost 1.5 times larger. It has about 70 million residents, which is approximately the size of the population of France. And its GDP figure in 2016 was almost $400 billion, which put it in number 26 in the ranking of GDP of the 196 countries. The control of chemicals in Thailand is mainly through the Hazardous Substance Act. However, certain products, such as cosmetic or pharmaceutical products, are not within the scope of this act and are regulated under their pertinent regulations, such as the Cosmetic Act and Drugs Act respectively. The Hazardous Substance Act was promulgated in 1992 and has been amended twice, once in 2001 and another in 2008. The Thai government welcomed the public to offer the feedback on the proposed Third Amendment to the Act from May to June of this year. A highlight of the proposal was the addition of the term transit. Currently, transportation of the hazardous substances and mixtures through Thailand requires business operators to notify the competent authorities twice. Once when the goods are brought into the country and another when the goods are taken out of the country. The proposal will help streamline the legal process of transporting chemical products. It should be noted that the proposal is not yet in effect. Based on this act, Thailand adopted the UN GHS Revision 3 through the notification of the Ministry of Industry concerning hazard classification and communication system of hazardous substances in 2012. Several other regulations are also issued under this act, such as those that set out safety data sheet format, labeling requirements, registration procedures, and fees. Under this act, 6 independent agencies published their respective annex, namely Department of Agriculture, Department of Fisheries, Department of Livestock Development, which in turn are under the control of the Ministry of Agricultural Cooperative, the Food and Drug Administration, Department of Industrial Works, and the Department of Energy Business. These annexes together make up the list of hazardous substances. It should be noted that since these agencies are able to issue their own regulations under the HSA, some discrepancies do occur. For example, the Department of Industrial Works simply requires the tags on a product label to be clearly visible, whereas the FDA requires the font size to not be smaller than 1 millimeter. Hazardous substances in Thailand are classified according to their control requirements. Type 1 being the least stringently controlled or the least hazardous, whereas Type 4 is the most stringently controlled or the most hazardous. Type 1 hazardous substances must comply with some specified criteria, such as labeling and transport requirements. Type 2 hazardous substances must be notified to and registered with the responsible authority. Type 3 hazardous substances require a permit and registration. and Type 4 hazardous substances are prohibited from production, import, export, or possession. However, certain Type 4 substances intended for research and development in small quantity may be exempted. The most significant annex of the list of hazardous substances is probably Annex 5.6. This annex categorizes the substances or mixtures not present in the list of hazardous substances in accordance with their hazard properties as Type 1 hazardous substances. The reason for its importance is enterprises are able to nominate substances onto Thailand's existing chemical inventory by notifying the government using this annex. In other words, Annex 5.6 is the regulatory mean that enterprises can use to add new substances to the inventory. There are currently two versions of the Thailand existing chemicals inventories, one which was published by the Food and Drug Administration and another by the Department of Industrial Works. The difference between the two inventories is the source of data. I must stress that both versions of the inventory serve as informative databases and neither has legal implication. The FDA, as a secretariat of the National Committee on Strategy Development for Chemical Management, published the first volume of Thailand Existing Chemical Inventory, or TECI. This version of the inventory contains over 7,000 single substances manufactured or imported in Thailand in 2012. As reported by various government agencies, such as the Customs Department and the Industrial Estates Authority of Thailand. Each substance is assigned an identification number called TECI number. Moreover, this inventory contains information such as common name and IUPAC names in English, substance name in Thai, harmonized system or HS code, regulatory control for certain chemicals, and production and import volume in 2012. The DIW's version of the inventory contains substances present in the list of hazardous substances and those that were notified to the agency between 2012 to 2015. You can determine whether your substance is present in this inventory by searching using CAS number or trade name of your product. A positive search will yield the substance's hazard type or its condition. The number of substances in this inventory is unknown. As mentioned earlier, Annex 5.6 is significant because enterprises are able to add new substances to the inventory by notifying the government. It is mandatory to notify the Thai government of chemical products, whether they be single substances or mixtures, manufactured or imported into Thailand, whose quantities exceed 1,000 kilograms per year, and those which have one or more of the 10 properties listed in Annex 5.6. This must be done within 60 days when the volume reaches the threshold. However, the agency encourages enterprises who manufacture or import the products below the quantity threshold to notify the agency as well, as it will assist them in tracking or manage chemical activities within the country. So what do you do if your product does not have the properties listed in Annex 5.6 or are non-GHS classified or are non-hazardous? ChemADVISOR has talked to the agency who recommends choosing one or more of the 10 properties which match the precautionary statements on the product safety data sheets. A benefit from filing Annex 5.6 is to circumvent possible future issues associated with the Thai inventory regulations. For instance, in the future, The business operators might be required to submit risk assessment reports on new or non-listed chemicals. It should be noted that the DIW has neither announced when the new regulation will be published or set out specific details as to what the regulatory requirements may entail regarding the chemicals not present in the inventory. ChemADVISOR is able to assist with regulatory compliance in terms of safety data sheet authoring or reviewing the documents, prepare dossiers which are needed to register the chemical products in Thailand. Most importantly, even though only Thai importers and manufacturers are able to notify the DIW about activities, in the interest of CBI protection, ChemADVISOR is able to assist foreign manufacturers by submitting the compositions of the products on their behalf. So we will take some questions.